Hi guys, it's me again, Attorney Al Jumrani, and welcome back to the House of Law. This is part 3 of the series entitled, Is the Law Biased? For this video, let's talk about the bias in criminal law. Handa na ba kayo? Let's do this! Kung hindi nyo napanood ang part 2, you can watch it by clicking here or by clicking the link in the description box below. In part 2, I explained the bias in labor law and showed you the different issues or controversies where the law sides with who else? The employee. Of course, at the end of the video, I explained that despite the pro-labor stance of our law, the law is not meant to prejudice the employer. The employer still has rights and prerogatives that are protected by law. Labor law therefore works to create a balance between the rights of the employer and the employee. Panoorin nyo yung video para malaman nyo kung bakit may imbalance sa relasyon ng employer at employee at kung bakit dapat i-equalize o ipantay ang relasyong ito. So for today's video, let's look at the bias in criminal law. First, let's define criminal law. Criminal law is the branch of law which defines crimes, treats of their nature, and provides for their punishment. Criminal law in the Philippines is primarily found in the Revised Penal Code. However, several penal or criminal statutes have been passed which penalize crimes not found in the Revised Penal Code. Halimbawa, may special law tayo for violence against women and children, issuance of bouncing checks, illegal possession of firearms, sale and possession of illegal drugs, at marami pang iba. Criminal law is seen in action during criminal prosecution, which is the procedure of bringing charges against alleged criminals and trying them in court to make them answer for their crimes. Explain natin ng kaunti ang nangyayari sa criminal prosecution. First, there are two parties to a criminal prosecution, the state and the accused. The state is the complainant or plaintiff, while the accused is, well, the accused or the defendant in the case. In every criminal case, the state is denominated People of the Philippines. The accused is denominated by his or her name, for example, Juan de la Cruz. Pero bakit nga ba ang People of the Philippines ang complainant sa isang criminal case? Well, this is because a crime disturbs public order and tranquility. Ginugulo nito ang katahimikan na siyang dapat manaig sa lipunan. Whether the crime has a victim or not, the crime is an offense against the state's interest and objective of maintaining peace and order in society. So ano na ngayon ang nagiging role o papel na ginagampanan ng biktima? Well, una, the victim generally initiates the criminal prosecution by filing the complaint with the office of the prosecutor o yung tinatawag na taga-usig. Kung may basihan ng reklamo, magsasampa ng kaso ang prosecutor sa hukuman. Pangalawa, nagiging witness o saksi ang victim dun sa isasampang criminal case. May mga pagkakataon naman na walang victim ang kaso tulad ng drug cases, illegal gambling at prostitution. In these cases, the police officer who arrested the accused files the complaint and becomes the witness in the case. In either case, the death, desistance, or lack of interest of the victim or police officer will not generally affect the case already filed because the state can still pursue the case. Remember, witness lang yung victim o yung police officer. The complainant is still the state. Also, the court can still render judgment based on other evidence. Thus, if at all, the effect of the death, desistance, or lack of interest of the victim or police officer is simply a waiver of the right to testify and in certain cases, a waiver of the right to recover civil indemnity o yung tinatawag na daños perjuicios. Ayan, I hope malinaw na sa inyo ang nature and dynamics ng criminal prosecution. Ngayon naman ay alamin natin ang mga ugat o source of biases in criminal law. Makikita ang mga ito sa ilalim ng 1987 Constitution. Ito ay ang mga sumusunod. Una, Article 3, Section 1, 1987 Constitution, which provides that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied equal protection of the laws. Related dyan ang Article 3, Section 14, 1 of the 1987 Constitution, which provides that no person shall be held to answer for a criminal offense without due process of law. Then there is Article 3, Section 14(2) of the 1987 Constitution, which provides that the accused shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face-to-face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. More importantly, if not most important, is Article 3, Section 14(2), first sentence of the 1987 Constitution, which provides that in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved. Note that even before criminal prosecution, the accused already enjoys certain rights. So, for example, Article 3, Section 2 of the Constitution provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Now, assuming inaresto na siya, susunod na iiral ang Article 3, Section 12, 1987 Constitution, which provides that any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he or she must be provided with one. Now, these rights cannot be waived except in writing and in the presence of counsel. Lahat ng nabanggit ay saklaw ng tinatawag na Miranda rights. Okay. Now, understand and remember these constitutional protections, and let's see if you can answer these questions. First, an accused was arrested by police officers without a warrant. The accused questions the arrest. Kanino panig ang batas? Answer, the accused. Warrantless arrest is the exception rather than the general rule. As a rule, dapat may warrant of arrest galing sa korte. Kung walang warrant, dapat ang sitwasyon ng pag-aresto ay isa sa mga sumusunod. Una, when in the police officer's presence, the person to be arrested has committed, is committing, or is attempting to commit an offense. Pangalawa, when an offense has just been committed and the officer has cause to believe, based on knowledge of facts or circumstances, that the person to be arrested has committed it. At pangatlo, when the person to be arrested is a prisoner who has escaped from a penal establishment or confinement facility. Now, if the warrantless arrest does not fall under any of those situations, ay dapat palayain ang akusado, pauwiin na yan. Okay? Okay, second question. The arresting officers claim that they were regularly performing their functions when they arrested the accused and confiscated the evidence of the crime. The accused questions the entire procedure. Kanino panig ang batas? Answer, the accused. In many cases, including People of the Philippines versus Ortiz, GR number 206767, September 11, 2019, the Supreme Court held that the presumption of regularity in the conduct of police officers cannot trump the constitutional right to be presumed innocent until proven guilty. Walay standard protocol sa criminal law youths. Hindi protocol nyo ang nasusunod. Patunayan nyo na ang protocol nyo ay naaayon sa karapatan ng akusado. Hindi ang akusado ang mag-a-adjust sa inyo. Okay, third question. Parehas ang timbang o weight ng ebidensya ng prosekusyon at ng akusado. Kanino panig ang batas? Answer, the accused. Under the equipoise rule, when the evidence of the prosecution and the defense are so evenly balanced, the appreciation of such evidence calls for the tilting of the scales in favor of the accused. Thus, the evidence for the prosecution must be heavier to overcome the presumption of innocence of the accused. People versus De La Iglesia, GR number 110991-92, February 24, 1995. Pang-apat, there is a variance or disconnect between the allegations in the information and the evidence of the prosecution, such that the information and the evidence are no longer pertaining to one and the same offense. Kanino panig ang batas? Answer, the accused. Dismiss the case agad-agad. Ano pa hinihintay ni judge? The second coming? You see, the variance is unfair to the accused as it violates the constitutional right to be informed of the specific charge against them and deprives them of the opportunity to defend themselves. Besides, they cannot be convicted of an offense with which they are not charged. Yan ang sabi ng Supreme Court sa People versus Opemia, 98 Philippines, 698, 1956. Okay, number 5. In crimes, the subject of which is a negative averment, like absence of a license in illegal possession of firearms or illegal practice of medicine, kanino panig ang batas? Answer, the accused. Where lack or absence of a license is an essential ingredient of the offense, it is the prosecution's duty not merely to allege that negative fact, but to prove it. People versus Makagaling, GR number 109131-33, October 3, 1994. This, however, take note, does not apply to possession of illegal drugs. Watch till the end to know why. Anyway, yan ang ilan sa mga bias ng criminal law na pabor sa akusado. Ngunit hindi sa lahat ng okasyon ay binibaby ang accused. Well, not literally. Sa mga susunod na sitwasyon, hindi paborable ang batas sa akusado at nasa akusado ang burden to prove his defense. Pag hindi niya napatunayan ang kanyang defense ay lagot, kulong kang bata ka. Sige, simulan natin. Una, when claiming the justifying circumstance of self-defense, the rule is that in invoking self-defense, the burden of evidence is shifted and the accused claiming self-defense must rely on the strength of his own evidence and not on the weakness of the prosecution. Velasquez versus People of the Philippines, GR number 195021, March 15, 2017. Pangalawa, when claiming the defense of insanity, the rule is that the defense of insanity is in the nature of a confession or avoidance. The defendant who asserts it is in effect admitting to the commission of the crime. Consequently, the burden of proof shifts to the defendant who must prove his defense with clear and convincing evidence. People of the Philippines versus Pantoja, GR number 223114, November 29, 2017. Pangatlo, when claiming the defense of consent of the woman victim in a crime of rape, the rule is, where an accused alleges consent to the sexual act as a defense, it is his burden of evidence to prove this allegation by substantial evidence. People of the Philippines versus Rapis, GR number 240662, September 16, 2020. Pangapat, in child rape or similar cases, the rule is that when the offended party is of tender age and immature, courts are inclined to give credit to her account of what transferred, considering not only her relative vulnerability, but also the shame to which she would be exposed if the matter to which she testified is not true. Youth and immaturity, sabi ng Supreme Court, are generally badges of truth and sincerity. People of the Philippines versus Pio Sang, 710 Philippines 834, 2016. In possession of illegal drugs, ito na yung panglima, the rule is that mere possession of the illicit drugs is malum prohibitum and the burden of proof is upon the accused to prove that they have a permit or clearance to possess the prohibited drugs. People of the Philippines versus Quijano, GR number 247558, February 19, 2020. Pang-anim, in falsification of documents, the rule is that in the absence of satisfactory explanation, one who is found in possession of and who has used a forged document is the forger and therefore guilty of falsification. Pakasum versus People of the Philippines, GR number 180314, April 16, 2009. So there you have them, the presumptions that are not so accused-friendly. However, be that as it may, always remember na hindi pa din mawawala yung responsibility o tungkulin ng prosecution na magpresenta ng malakas na ebidensya na makakapagsabi that the crime was in fact committed, and if unrebutted by the accused, the evidence will be sufficient to prove the guilt of the accused beyond reasonable doubt. That's the foremost rule in criminal law. At dyan po nagtatapos ang part 3 ng serye na pinamagatang Is the Law Biased? Watch out for part 4 wherein I will discuss commercial law naman. In the meantime, if you like this video, please give it a thumbs up. If you haven't subscribed yet, please subscribe and click that notification bell so that you will be alerted when I upload my next video. So, see you soon. Laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!